help with our community is, let them know how to transfer assets properly, how to properly plan, for the ultimate, demise, something that we are not sure when or when or where it'll happen. So these are some basic tools for the community to understand the process in regards to estate planning. Here are some objectives for today's presentation. Why is estate planning necessary? We're going to go over what is a will, what is probate, and we're going to talk about some issues with probate, such as joint assets, the process of probate, Pennsylvania inheritance tax. Cost is a big one. I know folks have questions about cost, and also life insurance. We're going to talk about why estate planning is necessary. Again, what is a will? What is a power of attorney? The types of power of attorneys, and also a living will. I know there are confusions among folks on what a will and what a living will is, and so we'll go over that today to clear up any confusions that are out there. So why is it necessary? So probate is necessary, and not estate planning is necessary in general, because there's some complex issues that are involved. For example, there are healthcare issues that are involved. There are legal issues that are involved, and of course, financial issues that are involved with estate planning in the process. With a proper estate planning, you ensure that your hard-earned assets go to who you want, when you want, and distributed by the person you want, and at the least cost as well. Planning is important. One, for control issues, again. You may want to control who gets your assets upon death. If you do not have the proper planning tools in place, your heirs, who you may not want to inherit your property, may get your property. So it's important to properly plan to control who gets your assets. It's also important to control your own medical and healthcare decisions. We all want to determine, how if we have the opportunity to determine how we, go out of this world. And estate planning is important to note who cares for minor and disabled children, which is very, very important. If you have minor or disabled children, their care, after your passing is critical. And also, planning is important for second families. This does happen where there are second families, or there are children that were born out of wedlock who feel like they don't get what is their share of their parents' estate. If you are amongst those folks who have a second family, then you have the opportunity to provide for your second family through your estate plan. So what is an estate? An estate is your financial assets, such as your bank accounts, any 401ks, any IRAs. It is your personal property, including your real estate, any vehicles, any collections you may have, any jewelry you may have. And so what is a will? I think this is a question that many folks have. So a will is a legal document intended to convey how one wants their property and their assets distributed upon their death. Any person who is at least 18 years old and is of sound mind can execute a will. What does a will do? A will allows you to appoint an executor, name the beneficiaries, and again, appoint a guardian for special needs or minor children. What an executor does is essentially, it is the personal representative of your estate. to carry out the provisions in the will. So essentially, for lack of a better phrase, an executor is a power of attorney over you after your death. So this person can step in your place to act as if they were you, after the appointment. So what happens if you die without a will? Your estate becomes intestate. What that means is that the state that you live in determines who is eligible to serve as the administrator, or the phrase administrator is used when there's no executor, when there's no will. So the state determines who is the administrator of the estate to carry out and transfer your assets. The state determines who gets your assets. And what is probate, essentially? A probate is the process that all estates must go through with or without a will. It's essentially an administrative process that is supervised by the courts. And here in Pennsylvania, it is supervised by the Orphans Court, and it is managed by the Office of the Register of Wills. Probate allows you to legally change title to property. This is important. Upon passing, when someone dies, you can only legally change property through the probate process if the property is held in an individual's name. So if you were to die tomorrow, this knock on wood, I apologize for that, but if someone were to pass away, and you want your property transferred, you have to go through the probate process to transfer the property. No one can then sign your name after your death to transfer property over. You have to go through the probate process. The probate process also gives notices to creditors that the debtor has passed away. Your administrator or the executor of the state is responsible to notify those creditors. What assets are subject to probate? So only probatable assets will transfer under your terms of the will, or if you don't have a will transfer intestate. So those are assets held in your name alone. Assets where there's a fractional ownership interest, which means if you or in multiple people hold title to property in individuals' names. And what are some assets that are not subject to probate? And this is important. This is key because this will help save some money for folks. So assets not subject to probate include assets or accounts held jointly with right of survivorship. So if there are any accounts or any property that say right of survivorship, they are not included in your probate estate because they already have a selected beneficiary. Any assets that are held in trust for are not a part of your probate estate because they are already have a selected beneficiary. Any assets, again, titled pay upon death or pay on death are not subject to the probate estate. And assets or accounts with beneficiary designations. So those include including life insurance accounts. Those are not subject to probate as to your probate estate. However, the beneficiaries of any property that is transferred upon death will be responsible for Pennsylvania inheritance taxes. So although you may not have to go through the probate process for property that is held with right of survivorship, the surviving person will still need to file and pay Pennsylvania inheritance taxes. So I'm going to talk about some assets that are held as joint tenants. So again, like as I mentioned, joint tenants inherit outside of the probate process. It's a method to avoid probate. And again, the Pennsylvania inheritance tax is due upon your fractional portion of the property. So if you are inheriting only 30% of the property, then you are liable to pay taxes, inheritance taxes on that 30%. But there are some issues with joint tenancy. So again, if you have property or assets that are subject to a joint tenancy, you are subject to the personal debts of the other tenant, subject to their creditors, and in divorce proceedings, things can get complicated with assets held as joint tenants. And then there are other life problems. I give you an example of if you are holding property as a joint tenant, and you want to sell the property, but the other owner does not want to sell. It gets complicated and things have to go through court, and a partition action needs to be filed in order for you to even sell your interest in the property. So joint tenancy does create a few issues. So what happens during the probate process? The executor or the administrator takes an inventory of all estate assets. The assets can be are appraised. The probate process is also a forum to resolve disputes. For example, if there is an administrator appointed who the beneficiaries or heirs believe should not be appointed, this is the forum where you would raise those issues, and the Register of Wills essentially acts as a judge in those matters to determine the outcome. And you also pay any administrative fees during the probate process. There are fees associated with probate, and depending on the amount of assets you have, it can get costly because the probate fee here in Philadelphia and Pennsylvania in general is based on the amount of your estate and the number of assets that you hold, the value of the assets that you hold. During probate, your executor or administrator also pays debts and pays off any creditors. Creditors still may attack the estate for its value if the deceased person owed money. In Pennsylvania, a creditor has up to 7 years to try to collect what's owed to them. And during a probate, if the probate was not advertised in a public newspaper, which I'll get to in a few minutes, or it's 3 years if it was advertised. Again, during the probate process, you have to pay Pennsylvania inheritance tax. In a few moments, I'll go over what that tax looks like. And finally, the administrator has to pay final income tax obligations of the decedent. So the administrator of the estate or the executor of the estate needs to file a final income tax return for the decedent if they were working during that previous year. And the administrator or the executor then distributes the remainder assets of the estates to the heirs and beneficiaries. What are the costs associated with probate? Again, there are filing fees. Again, in Pennsylvania, the filing fees at the Philadelphia Register of Wills, the filing fees are based off of the value of the estate. So it's a sliding scale. So the more assets that are in your estate, the higher the filing fee will be for the Register of Wills. There's publication and bond fees. Again, when we go through the probate process, we must advertise in one newspaper of daily circulation and also one legal newspaper. And there could be bond fees associated with the probate. If you are an out-of-state resident and you're looking to probate in the state here in Pennsylvania, a bond may be required, to be allowed to probate, because the Pennsylvania courts do not have jurisdiction over you outside of Pennsylvania. So they need a bond to secure, to make sure that you will distribute the assets according to Pennsylvania law. There are executor's fees. The executor and administrator is entitled to a fee based on Pennsylvania law. There are attorney fees. And again, inheritance tax, which is, I keep mentioning that because that is something that is big with the probate process. And it's very, very important that folks pay attention to the inheritance tax. And creditor claims. The executor or the administrator must pay off the claims of creditors during this process. Again, what is inheritance tax? Inheritance tax is due 9 months from the date of death. It's paid either by the estate or by the heirs. Honestly, the state does not care who pays it. They just want it. They just want it paid. Um, but what if there isn't enough cash to cover the tax? Then assets must be sold, or the state can place a lien on your property. This is why I mentioned inheritance tax, so many times throughout this presentation, because in the Commonwealth of Pennsylvania, they will place a lien on your property if you have not paid inheritance tax, and they will also charge you penalties and interest on top of that as well. So paying inheritance tax on time, or entering into an agreement to pay the inheritance tax on time is key, because if not, it will devalue the estate, and you can be dealing with a lien, for years to come until it's paid off. So yes, so inheritance tax, is there a tax due? Yes, it's based on the percentage. Uh, the percentage tax is based on a relationship to the decedent. So here is, if you're a spouse, you pay 0% for inheritance tax. If you're any children or grandchildren, you pay 4.5% of the estate value on inheritance tax. Any siblings pay 12%. Collateral is everything else. So if I'm going to inherit something from my aunt, my uncle, I have to pay 15% inheritance tax on that. And for charities, there is no inheritance tax due. Oh, some difficulties with the probate process. Probate can take time. Given now, remember, probate is an administrative proceeding with the Register of Wills. We all know during COVID, government was shut down. People are working virtually now, so things can take time of the probate process. So that's something to be leery of. Also, financial companies take time to respond. If there are mortgages on the property, if there are any debts owed, by the decedent, the administrator needs to collect and gather all this information. And again, that can take time for them to respond to get an accurate measure of what the value of the estate is. Some occasions may require copies of legal documents from other states, again, which takes time. If the decedent held property in multiple states, all of those assets need to be included in the probate. And the probate becomes a part of the public record. So if you probate an estate, if the estate has any assets, particularly any real estate assets, you can expect to get phone calls from individuals trying to buy that property. It just is what it is when it comes to the probate process. There's is no way to get around your probate estate being a public record. You can have multiple probates at the same time. For example, if property is held in grandmom's name and grandmama's deceased, and the mom is also deceased, you need to open up an estate for a mom and grandmom to legally transfer a title to that property. Again, which add costs and add time to it as well. And again, there could be an ancillary probate. If you resided in multiple states, you may have to probate in multiple states depending on what the assets are and the rules of those states. And it typically occurs, again, with multiple properties in separate counties and separate states. I'm going to touch a little on what a power of attorney is. So a power of attorney is a written legal document that gives a person to act on behalf of another person. It must be signed, dated by the principal, and witnessed by two adult individuals, and also must be notarized. If the principal can't physically sign, then they are allowed to sign by mark. And any person signing a POA on behalf of someone else may not be a witness when signing the power of attorney. Unless specified, all power of attorneys are durable. What this means is that they survive any incapacity of the principal. So if the principal were to become, if they have dementia or any other ailments that prevent them from having the capacity to sign documents, the power of attorney will still withstand that if it was signed before the incapacity happened. And the agents owe a fiduciary duty to the principal, which means the fiduciary duty means that it is a financial and ethical relationship that is there. And so there are certain things and certain acts that the agent must do on behalf of the principal. There are two types of power of attorneys. Financial power of attorney. This allows your agent to conduct your business, to perform transactions, and to make personal and family decisions on your behalf. These powers can be very broad or they can be very specific. It's all up to the individual and what powers you want to give away. And there's a healthcare power of attorney. Here, this allows your agent to speak with medical professionals and make medical decisions on your behalf in regards to your treatment and care. In your medical power, your healthcare power of attorney, the principal, you can specify the exact authority and the exact decisions that the agent can make on your behalf. And healthcare providers or their agents cannot be witnesses when signing a power of attorney. There are two other types of power of attorney. A springing power of attorney becomes effective at a future date or upon the occurrence of a specified event. So if I draft a power of attorney now for myself, but I don't want it to go into effect until 3 years from now, that's a springing power of attorney. Or I don't want it to go into effect until I'm incapacitated, that's a springing power of attorney. Again, it includes any disabilities or any incapacity. Upon divorce, power of attorneys do not survive unless the POA says it specifically. So if you are married and you name your spouse as your power of attorney, the moment you file that divorce action, that power of attorney does not survive. It is null and void. So that person will not have the ability to act on your behalf. What is a living will? So a living will is a document that provides instructions for healthcare and healthcare directions when it's determined that you are incompetent and you have end-stage medical conditions or are permanently unconscious. So here in a living will, you determine things like if you want to be resuscitated, if you want hydration, if you want to be on a respirator, and things like that. You get to determine what type of end-stage medical care you get with a living will. Some folks also call it a advanced healthcare directive as well. You may hear that term thrown around. You must be 18 years or older, graduated high school, married, or an emancipated minor to make a living will. It must be signed and dated, but this must have two witnesses, but it does not have to be notarized. Also, when you're signing your living will, healthcare providers, again, cannot be the witnesses to your living will. So minimum estate planning requirements. So we have a last will and testament. Again, this decides who inherits your estate after death. You may also include instructions for minors or disabled persons legally in your care. There are financial power of attorneys. Again, you appoint an agent to represent you financially. There are healthcare power of attorneys. where you appoint an agent to make medical decisions for you. And also there's a living will that outlines your end of life wishes. And with that, I'll take any questions.
Thanks so much, Jeffrey. So we do have some questions from both the chat as well as questions that we had received through our Equally Informed Philly text line. So Lily will be helping me state these questions to you, and we'll drop it in the chat too. So the first question is, how do you avoid the inheritance tax?
To avoid inheritance tax, the assets must not be probatable assets. So again, there's no way to avoid it if assets are part of your estate. You need some advanced estate planning tools to avoid inheritance tax, such as you need trust documents. Assets held in trust are not a part of the probate estate, therefore they're not subject to the inheritance tax.
Great, thank you. And I think Lily's going to ask the next one.
Oh, this is fitting for this question. So what is the role of a trust in estate planning?
So again, trusts are an estate planning tool that allows you to determine, who gets assets in a different way. So essentially, trust is a legal entity. It's a responsibility, and it's also creates a fiduciary duty. So trusts are documents that can be living, and they can also again, similar to a will, but they are not a part of you. You can transfer assets, but they are not a part of your probate estate. So they're living documents, they're living entities that are not subject to your estate.
Next question we have is, can you tell me about the gift tax and its filing requirement?
So gift tax is a federal tax. I'm not a tax attorney, but what I do know about the gift tax in 2021 is that if you transfer a gift with a value of $15,000 or more, you're subject to pay the gift tax, and this is while you're alive. So if you have something, if you want to transfer a house to someone for a nominal fee, and the value is over $15,000, you may be liable to pay the gift tax. That's something you have to talk to an accountant or a specific tax attorney about.
So you mentioned the probate process earlier. What if someone doesn't have a plan prior to someone's passing away? What can their loved ones do to formalize getting their estate figured out?
So if you have not had documents drawn up to plan, then the estate is intestate. And again, the state determines who gets the assets. The state determines who is the administrator to distribute the assets. So that will, it's already predetermined, for you when you go to the Register of Wills to try to probate the estate and to transfer those assets over.
Next question we have is, how can I protect my assets from nursing homes?
To protect your assets from nursing homes, you can create what's called a Medicare trust. However, any documents that were or any assets that are transferred to the trust are still subject to the nursing home if it's within 5 years. After 5 years of the transfer of the assets to the trust, then it becomes fully protected.
Awesome. So this was a question that came from our text line. If you want to join it, you can text Equal-Info to 73224. But this person asks, I'd like to know how you can plan your funeral with the funeral director without giving them your policy.
So you don't have to give a funeral home your insurance policy. That's just a practice that they like to use, so they can see how much money is out there for the funeral. They're going to want to try, to make as much money from a funeral as they can. They're in business. But you do not have to share the policy with the funeral director. Their job is to plan the funeral, give you the cost of the funeral. And if you are the beneficiary of a life insurance policy, you don't even have to pay for the funeral with life insurance money. The life insurance, if you're a beneficiary, that's your funds. You can decide what you want to do with that money if you're the beneficiary of a life insurance policy. It's just been practiced to pay for a funeral with life insurance money. So you do not have to give the policy to the funeral director.
This is another question from our text line. This is someone who is a senior and needs to have a living will drawn up. If you have any resources.
Well, Senior Law Center is a great resource for seniors who need estate planning documents drawn up. They may be able to provide those documents to seniors for free.
And then we have a question from the Zoom chat. If a principal power of attorney was issued in another state, will adjustments have to be made if they relocate to Pennsylvania?
No, that power of attorney, if it's valid, if it was drawn up in another state, is still valid here in Pennsylvania.
Another question we have is, how do I change my beneficiary, and should I make my beneficiary my parents who are currently in their late 60s?
If the question is in regarding changing a beneficiary on a will, you will have to make a new will, essentially, or add what's called a codicil to the will. But the easiest way to clear up any miscommunication issues in a will is to make a new will.
What is the typical cost of having a will written up?
That all depends on the value of the estate and the amount of assets you have. So it all depends. It's not I can't give you a flat figure on that. And it varies from attorney to attorney.
Awesome. Well, those are all the questions we received, but if anyone who's on the call wants to ask one, feel free.
That was great, guys. Great questions. If anyone feels free, they want to ask any more questions, feel free. But I have one question, not necessarily a question. I want to get your advice or opinion on.
Okay.
Moving forward, what would be the best advice coming from you, knowing in your background of being an estate planner and a estate lawyer? Would you give Philadelphians as far as just getting a will done and getting done in a timely manner? Don't wait till the last minute. Of course, as far as like planning, end of life planning, and in general, like what's some advice that you would give to them moving forward?
I say if you own any assets, if you own a house, you own a car, and you wanted to specifically go to a specific person, individuals upon your passing, you need to have a will. If you have multiple kids, you need to have a will. We may think that our children and our family may get along, but we all know upon death, people act different. I'll just say that. So you need to have a will to avoid those fights.
It's great advice.
Got one more question, kind of related. How is my property transferred at death? You kind of touched on this in the presentation.
Yes. So if your property is held in your name, upon death, the executor or administrator has the ability to transfer your property. And they are the only individuals, entities that can transfer your property at death. No one else can transfer it but your executor or your administrator. And you are there, and you can have multiple executors and multiple administrators as well. Folks can be co-administrators, co-executors. You can name that in your will.
We have any more questions? Pretty good.
Any more questions?
Look like we're good.
Yeah.
All right. Appreciate everyone for joining us. Thank you. Let's thank Jeffrey Young for joining us today and giving us advice for moving forward in the life planning and estate planning and wills and power of attorneys and so on and so forth. Like, this stuff is important, y'all, and it's great that we have these things in place to try to protect us and protect our loved ones. So we appreciate you, Jeffrey, for joining us and sharing this information. Also, before we go, I would like to inform you about another project that we have. It's called With Love. It's a With Love. And it's With Love is a project from Resolve. It provides an opportunity for those who've lost close friends and family to COVID and want to say goodbye. Didn't have the opportunity to say goodbye before their unfortunate pass. We know nothing can make up for it, but in your own way, whether it's a written letter or an audio recording, anyone in Philly who has suffered a loss due to the pandemic can have a chance to publicly say goodbye. So how you can do that is you can text With Love to 73224 to get involved, or fill out our submission form to get started. And that will be in the chat, the actual bit link in the chat. Any more questions before we wrap this thing? Thank you again. I'm gonna keep saying thank you for joining us. Any more questions?
No problem.
Last time. We're good?
Thank you.
You're welcome.
Thank you so much, Jeffrey.
All right, no problem.
Thank you.
Anytime. I think we need to do one on trust, Derrick. So we have to figure that out so I can do one to specifically talk about the different types of trust and what trusts do. So just let me know. We can plan that one.
Appreciate you, man. I'll be in contact. All right, guys. Have a great weekend.
No problem. Have a good one.